Everyone, we're going to get started. We have to be finished by 2 o'clock, and I know the House is going in session at 1:30, so we've got some people that are a little antsy sitting here right now. And to start us off, what's your mic number, Senator Burns? Okay. If you would open us in prayer.
You join me, please. Father, we're grateful for today. We're grateful for the privilege and the opportunity of service. We're grateful for the challenges and the patience that you extend to us. Grant us your grace, grant us your wisdom. Help us do your work here today. In Christ's name, amen.
Okay, we have 4 bills on our agenda for today. And we're going to start with House Bill 76. Chairman Powell, you're up. And we do have sign-up sheets up there, so different ones for each bill. So if anyone wants to testify, you need to sign up. Okay, sir, you better tell us the LC number.
Thank you, Madam.
Sorry. Yeah.
Thank you, Madam Chairman and ladies and gentlemen of the committee. I bring to you today House Bill 76, and let me dig out the committee substitute. Committee substitute LC 365559S that you
That's
should
what we
have.
have.
That you should
Yeah,
have.
it's actually not a committee sub, it's just a sub. So
It's just a sub.
you can
I'm sorry.
proceed.
Thank you so much. The underlying bill, ladies and gentlemen, was really quite simple. This was updating the licensure requirements for the marriage and family therapist. This hadn't been changed in many years and it was a little bit antiquated by the national standards. And this basically updates the coursework and the practice requirements to be a marriage and family therapy for marriage and therapy education at our universities. The Georgia law, as I said, hadn't been updated in several years, and this puts us in line with the National Accreditation Commission on Standards, which were revised in 22. And that's what it would do. That's the underlying part of the bill, the original bill. If you'll look on the sub, Section 1 repeals under Title 43, it repeals and reserves Chapter 1A. This is the GORP process that many of y'all may know about. GORP is one of those, I've been here 34 years, and GORP was one of those mystic things that we never could figure out what in the world it was good for except to be a gatekeeper, which was really an infringement on yours and my legislative abilities. A member may want to put in a bill on licensure. Well, it had to go through GORP. GORP was always controlled by the governor's office. They would put somebody at various agencies on there to see if whatever bill you put in as a legislator actually merited whatever changes, either the creation or whatever. And quite honestly, ladies and gentlemen, that was kind of an impediment to your elected legislative duties. Now, to his credit, this governor has used GORP. Virtually everything. If there was a fly put on the back of a mosquito, they wanted GORP to look at it for any change, not just the creation, but any changes to any licensing committee. Other governors, some's used it, some haven't used it. I remember that former Governor Miller very seldom ever used GORP. But that being said, I give due credit to the governor that he has realized that this is an antiquated stumblement and impediment to the legislative process, and it's time to do away with it. I would tell you that this isn't my handiwork, because I don't control what governors do, but I will certainly tell you I tip my hat to Governor for doing this, that they've decided to do it. The other change into this is a practical change that's needed in Section 3. If you look starting on line 20, any governor appointed seat of the executive branch, board, commission, or council shall be filled by appointment of the governor as provided by law when the seat becomes vacant upon term expiration or when declared vacant by the governor. This is cleanup legislation that they have decided they need in the governor's office, because in this cleanup, you have some of the appointees of a few of the boards that unless they just outright resign, then they can't be replaced. And there has been some instances of questionable conduct or misconduct, and this gives the governor that ability in those cases to fill a vacancy. And that, ladies and gentlemen, is quite simple. Turned into the simplest bill I've ever done. It's turned into maybe one of the better bills, except for maybe cannabis and COAM.
Thank you, Mr. Chair. One question about the last section that you mentioned, line 120 to 23.
Yes, ma'am.
We are sent lists of board and commission appointments all the time for legislative approval. This would still be the process, correct?
I would think so. I see the governor's floor leader. He would know better than I. I just only follow directions that are pretty good directions.
I'm just wondering if we need to add language to make that clear.
So, Madam Chair, I don't know the exact answer to that. I'm assuming that that process would still be in place the way that it is. But I will say to the chairman, thank you for bringing this piece of legislation. And on behalf of the governor's office, we are fully in support of this substitute.
Thank you.
Okay, and Senator Brass, what's your number 13?
Yes, Senator. Thank you, Madam Chair. So I want to piggyback here with Representative Powell and his infinite wisdom on and working with me on this committee sub. So the repeal of the occupational regulation and legislative review, that's in section 1. We're repealing that entire code, and I kind of wanted to give a little background on, I guess, what I would call the final straw. Was I had a bill in under review in committee a few weeks ago, or a bill I was interested in, and there was debate on the committee as to whether that bill and that change needed to go through GORC, and it was under my understanding that on a licensing bill, if it wasn't changing scope, then it did not need to go before GORC review. And so, anyway, we go through the process committee, and after the committee, I reached out to the governor's office and asked, I said, can I get either an email or a letter or something saying whether I need to go, this bill should go to GORC or not. And so I was given a phone number to call at GORC, and I call over to GORC and asked them about the bill, asked them if it needed review, and they weren't even aware of the bill. They weren't even aware of what we were talking about. And if you go into the code section of what GORC is required to do, they are required to review all licensing bills. Well, here we are having all these licensing bills. We don't know if it goes to GORC before we introduce the bill. We don't know if it goes after. And so, anyway, I have a conversation with him about all this, and he says, well, I'm not aware of this bill. Then he looks at it, he goes, oh, this bill. Well, you need to go talk to the governor's office. I said, well, I did talk to the governor's office. The governor's office told me to come talk to you. And he said, well, you need to go to the governor's office. So I go back to the governor's office. We have a talk, and we came up with a solution of this. We're going to get rid of GORC. And we did not, for the record, we did not send this to GORC for review.
Thank you, Senator Brass. In my conversations with the governor's office about this, this is not the first time that this has come up. So there's a history that predates your bill, but I'm sure you knew that.
I did. I got other bills that predated my bill.
Okay, let's see, Senator Jackson?
Yes, thank you, Madam Chair. I thank you so much for your underlying bill. I'm very appreciative of it and extraordinarily supportive. I have a technical question that maybe some of the lawyers can answer. I understand we're in a world where we catch rides on things. But I don't understand how Section 3 is relevant and how it was able to attach itself to what is an underlying really wonderful bill. And so I don't want these standards that we have for LMFTs to not go into effect because we've got this other we're using this as a vehicle. So I understand why GORC is a part of this. It's in Title 43. Makes perfect sense to me. I just don't know how Title 45 found its way attached to here. So perhaps you can provide some insight.
Yes, ma'am. There's been a long-standing rule as long as I've been in the legislature that there's two ways that you can amend a bill as a rider or a Christmas tree or whatever else. One is by code section and the other is by subject matter. And the subject matter to this would still be under the same thing, and it's the appointment power of the boards and how they could be replaced as opposed to the original bill that was a board and doing away with GORP.
Okay.
And then most importantly,
The governor wants it.
that decision is ultimately made by the governor.
Right. Until somebody says
As a spokesperson of Legislative Council, we cannot comment on that, but if the governor and the member, the author of the bill, are finding that it is related, we have no comment. We remain objective.
Just a question about Section 3, Madam Chair. Your concern about the governor's appointment powers and whether or not it would require legislative concurrence? Would you clarify that? Would you clarify that, please? Is there an issue there?
I think our floor leader got the answer to that.
Yes, the answer to that is it's already been addressed and it does not impact the current process.
Okay, we do have two people signed up to testify, so if you'd stand by, Mr. Chair, and Elizabeth Apley. And Ms. Apley, I know you know that we're short on time.
Madam Chair, members of the committee, my name is Elizabeth Apley. I represent the Georgia Association for Marriage and Family Therapy, and thank you for hearing this bill. Thank you to Chairman Powell for bringing the bill. Our section is in Section 2, which was the original House Bill 76. All this does, as the chairman said, is to bring Georgia's licensing requirements for curriculum and practicum education in line with the national accrediting body that updated its standards last year. We reduced the number of clinical supervision hours to bring us in line with the other southeastern states, all of whom, Alabama, Florida, Mississippi, North Carolina, South Carolina, Tennessee, Texas, and West Virginia, all provided for 1,000 to 1,500 hours, and we're now bringing us to 1,500 hours from 2,000. This started as a recommendation of the House Rural Development Council that said that our licensure requirements for mental health professionals were out of line with our neighboring states. And we did go through GORC, and we received a unanimous approval. You know, the purpose of this bill protects the quality of care delivered by these professionals. We want to be sure that the people who are educated in Georgia and licensed in Georgia are able to go to other states. We want to protect the quality of care provided to our patients. GORC concluded that this would have a positive economic impact on the state, and it would help attract and retain qualified individuals, and that Georgians would see an increase. We've had no opposition. All of the professional associations under the composite board, NAMI Georgia, Voices for Georgia's Children, and all the universities training these individuals support the bill, and it passed the House unanimously. And we appreciate the governor's interest in the issue.
Thank you. I think you do have a couple questions. Senator Robertson?
Yes, ma'am. A family and marriage therapist, is that the same thing as a marriage counselor?
Yeah, marriage and family therapist, yes, sir.
Okay, I've only had experience with one of those, and that was in my first marriage, and that didn't work out well, so I was just trying to was trying to make sure we were talking about the same people.
What about your second?
I didn't need one in my second marriage, and my third marriage is going well.
TMI, Senator, TMI.
Thank you.
Practice makes perfect.
Was there another question? Okay. All right, thank you very much.
Thank you,
And
Madam
we also have Aubrey Alliance.
Thank you, Madam Chair, members of the committee. I'm Aubrey Valines. I'm the General Counsel for the Licensed Professional Counselors Association. We're one of the 3 professions licensed under this code section. We support their efforts. We support the bill. We also totally support the repeal of GORC. And I'm authorized to say that my advanced practice nurses support it, my chiropractors support it, my LPCAs support it, and my optometrists support it. In all my years of lobbying down here, which I think are 46, it's been the most arbitrary and capricious applied law I've ever seen. It always depends on one thing, whose ox is being gored. So we ask you to go ahead and repeal it. Thank you very much.
Thank you. Any questions from the committee? Senator Mallow? Aubrey?
Yes, sorry.
Oh, I don't have a question, Madam
Oh, you don't? Okay.
At the appropriate time, I'd like to make a do pass motion.
Okay. Mr. Chair, you want to come back? Okay. Any other questions from the committee? Okay, then it is the appropriate time.
Madam Chair, I make a motion that we do pass LC number 365559 Sierra.
Who wants the second? The committee. Second? Brass. Okay. Any further discussion? We have a motion and a second. All in favor, please raise your hand. Any opposed? Okay. Thank you, Mr. Sheriff.
Thank you, Madam Chairman, ladies and gentlemen.
Do you have a Senate sponsor yet?
I think Senator Brass. And my former wife and my future wives will thank y'all for passing this forward.
Okay, thank you very much. Okay, next we have House Bill 291. Oh, okay. Chairman Ballinger, you want to come up then? And which one do you want to do first? 460? Okay. Go right ahead. You've got the floor. We're doing House Bill 460, and that's LC 480870S. Is that what you have, Madam Chair?
Yes, ma'am.
Okay.
House Bill 460 just clarifies when a child is eligible for a court-appointed attorney in juvenile court. Basically, it clarifies that a child has an attorney in legitimation during a temporary guardianship, extended care services and trials about extended care services, and a child in defects custody under exceptional circumstances are all those instances which are clarified by House Bill 460. And I'll be happy to answer any questions.
Questions from the committee? Senator Robertson?
Yes, ma'am. So reading the title, Child's Right to an Attorney in Legitimation Proceedings and Removing Right to Attorney of All Parties in Dependency Proceedings. So do all parties currently have that right, correct?
I'm sorry, what part are you reading? What line?
I'm reading the title of the legislation talks about, are we removing the right of anyone to have an attorney?
No, we're just clarifying when the child is eligible for an attorney.
Perfect. Thank you, ma'am.
Other questions from the committee? Okay, we don't have anyone signed up to speak, so.
Make the motion to pass.
Hang on. Okay. We've got a motion to pass from Senator Payne and a second from, who's doing the second? Senator Brass? Okay.
And that's, Madam Chairman, that is on House Bill 460. And it's on LC 480870S.
Okay, so we have a motion and a second. And any further discussion? All in favor, raise your hand. Any opposed? Okay, thank you very much. Do you want to do your next bill? And Senate sponsor, I believe.
Senator Brass.
Okay. Your next bill is House Bill 509.
Okay, House Bill 509 just basically adds an act of family violence to our burglary statute. Right now, if you illegally enter the dwelling of another and commit a theft or commit a felony, then you have committed the offense of burglary, which is a felony. However, if you kick the door in, beat the snot out of your ex-lover, and then leave, you're guilty of 2 misdemeanors, criminal trespass and battery. We seek to make this a felony by adding it to the burglary statute, where if you enter illegally into the dwelling of another and you commit an act of family violence, only including offenses between current and former spouses, current and former romantic partners, or family members. Only in those limited instances you can be charged with a felony offense of burglary. I'll be happy to answer any questions.
You do have a question?
Thank you, Chairwoman Ballinger. I have a question. The OCGA gives a list of definitions under the family violence statute of those that fall within that.
Mhm.
Any reason why we don't just adopt that code section so it's consistent in this bill so that you have the list of definitions as to who that would pertain to under the already existing statute?
This was, the language was actually garnered from the Prosecuting Attorneys Council and prosecuting attorneys actually that are domestic violence resource prosecutors. And they felt like this language was sufficient enough and specific enough for the acceptable prosecution of these cases.
Yeah, just a follow-up with the definitions. One of the things that, being on this committee, that we found even in the juvenile statute is that when we don't bring everything together, we sometimes create these unknowns in the code section because it's defined in one place, but this would be a new law and the definition may or may not apply here because it wasn't explicit. And I just have a concern that we bring the language and the definitions of the code section just so we're consistent. And maybe Legislative Council could maybe answer that for me about, those definitions of family violence. Because we say family violence, but we don't reference the statute that we have the definitions in here.
Thank you. Legislative Council, it was Madam's intent, I believe. We're not changing any of the definitions of domestic violence or family violence. What we're doing is changing the burglary statute and including you no longer have to commit the offense of burglary with this law. You no longer have to break and enter with the intent to steal a certain amount. That's a felony. You don't have to beat someone up to the effect of aggravated assault or aggravated battery. It's just enough that you break into your former lover's house and button their lip one time. That is what we're changing. We're not changing the family violence statutes. We're changing burglary. And I think that was the intent of Madam Chair.
Madam Chair.
Go ahead.
If I can be acknowledged. 5?
So the rest of us was next, but.
That's fine.
Yeah, just to piggyback off that. For example, what is the definition for a romantic partner?
Somebody who's been engaged in a relationship.
Is that in the statute?
It's not clear. It's not specifically defined in statute.
Yeah.
It is elsewhere, but not specifically defined here.
And I think that's what my colleague was saying, was that with these acts, and I agree with the intent of the bill.
Mm-hmm.
With family violence, these terms are specifically defined. Whether it's family member, spouse, those terms tend to be defined. Something like a romantic partner does it mean physical? Does it mean emotional? That could be interpreted in different ways. And it would be helpful to have, if we're going to do that, have a definition defining romantic partner. Similarly, the definition of a family member, making sure that it's consistent with what we already have in code. Or if we're trying to change it, then making sure that we have a clear definition of what the scope of this law would be.
Well, that would just be up for the prosecuting attorney to make that case. and to make sure that that definition was followed. And it would be up to the judge to make that ultimate determination on their interpretation of the statute as written, and as it will be codified by Ledge Counsel. So it's really up to the prosecutor and the judge to make that ultimate decision on what they would define and what they wouldn't define.
Okay, you've got a few more questions.
Okay.
Sarah Jackson.
Thank you so much. So if we look at the Family Violence Code and the definition of family violence, there's very specific people who are named, right? Past or former spouses, past or present spouses, persons who are parents with the same child, parents and children, step-parents and stepchildren, foster parents and foster children, or other persons living or formerly living in the same household. So that's how family violence is defined. When you delineate these out, you leave out certain classes of people. So
who am I leaving out?
So you would be leaving out so people who were not actually necessarily, so other persons who were living or formerly living in the same household.
We didn't want to include those. We deliberately left them out. If your roommate comes back and he's mad because you've broken his PlayStation and he gives you a pop across the mouth, I don't want him charged with burglary and active family violence. That's why we narrowly curtailed it to just these people. We didn't want everybody included in that family violence. Well, I think we all know it's 2023. People who live together. I mean, that was kind of our back door into getting to, gay couples or, people like, those sorts of kind of outside the purview that we didn't really want to do. I don't think the folks 20, 30 years ago wanted to spell out in statute, but we're really trying to get at.
Sure.
But those people, the roommates that, he gets a slap or a push or whatever, whenever he tries to come and get his PlayStation and it's broken and he gets mad at his former roommate, those are not the people living in terror. It's the domestic violence victims that we're really trying to help here.
Sure. And then alternative, so you don't include some people, but then you add another class of people, which would be family members writ large. So that could be first cousins, second cousins, I don't know. And so I think we are concerned about it not being clearly defined and constrained amongst the persons that you truly want to catch. So I hear your explanation for why you don't want to include just roommates, but that term, particularly family members, is so broad that I think it causes us some pause.
Well, it's deliberately somewhat nebulous because we want prosecutorial discretion. The prosecutor is only going to charge what they think they can prove. If they think they can prove the familial relationship, then obviously they'll proceed with that. If they don't feel that they can prove the familial relationship, obviously they'll look elsewhere for another more appropriate charge. And an act of family violence is very, very clearly defined within our statutes.
I turned my light off. The chairwoman said exactly what I was.
Okay. Did you? Okay. Any more questions for the author? We do have one person signed up to testify.
Okay.
Carlos Rodriguez. You don't want to testify? Okay. 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 If there's no further questions from the committee, then I'll entertain a motion.
Madam Chair, motion do pass.
Is there a second? Second by Senator Hatchett. Okay. Any further discussion from the committee? Okay. All in favor, raise your hand. All opposed? Which? Sorry, could you do it again? Okay, all in favor, raise your hand one more time. And all opposed? Okay, so what's the count?
6-9. Oh, I'm sorry, 6-3. 9 total.
60? Okay, the motion passes 6-3. Thank you.
Thank you, Mr. Chair. I appreciate the time and attention of the committee. Thank you so much. Senator Payne.
Okay, we have one more bill. We're moving right along here. Representative Scoggins, you're going to talk to us about House Bill 291.
Yes, ma'am. Thank you, Madam Chair and committee members. This is House Bill 291 I bring on behalf of the Council of Probate Judges for the state of Georgia. This bill would amend Title 29 to broaden the list of providers who can do an evaluation on an alleged incapacitated adult or child. This will allow different people to do the evaluations. The court were having problems getting a licensed physician or a psychologist to do the evaluations, and the court was getting backlogged with guardianship cases. And so this is our attempt to try to expedite those cases and get a guardian appointed for those wards. And I'm happy to answer any questions that anybody may have.
I actually have a question for you. I'm not quite sure what the evaluation involves for this purpose, but we're putting a lot of people in there that aren't currently in there, including LPNs.
Right.
And there's a big difference in the training between LPNs and some of the other folks on the list. So I'd just be interested in how we got to that list.
The state bar drafted this legislation, and this was with the Council of Probate Court Judges, and they come up with this list of expanded providers for the evaluation.
Other questions from the committee? Senator Robertson?
I just want to be perfectly clear. What we're talking about is expanding the list to those individuals who can determine if an individual is incapacitated for an adjudication to be made by a probate court judge as to whether to place them somewhere or just make a determination on
just
on
to
a hearing?
appoint a guardian of that ward. For instance, in a case where someone's in advanced age and has Alzheimer's disease, the child steps up to the court and wants to get guardianship appointed for their mother, father, whatever. This will allow them to expand that list of providers to get that done.
Judge, you know, you and I are really good friends, and I appreciate you a lot, but once again, in that particular circumstance,
right,
to go to the chairwoman's concerns, I promise I'm not dying on this hill. We got licensed marriage and family therapists and other individuals in here that, if we're talking about guardianships,
right,
I'm a little concerned that we may have some individuals in there that may not have the skill set. I have a tremendous amount of respect for the man or woman that sits on the bench, because they hear everything that comes in there from all sides every day, all day. But I'm a little concerned that we're getting individuals in here that are basically, to a degree, taking rights away from an individual.
That's what you're doing.
Exactly, who are woefully unqualified to do that. And I'm wondering if we may need to work on this a little bit.
Well, the court has the authority to appoint a licensed psychologist to do if they're not accepted, you know, they don't agree with the evaluation or they don't think the evaluation is in depth enough. The petition pretty much is about 30 pages long to do a guardianship, and it's pretty much a set answer list of questions that the doctor or psychologist goes through when they're evaluating the person. So it's a set list of questions pretty much through the application. And I'm pretty happy with if the committee wants to move forward with addressing that issue. There are concerns that you're having, and I don't have a problem with that.
In these set, Madam Chair, if you don't mind,
Sure.
in these set questions, they are evaluated by by one of these professional individuals, or they're
Yes.
evaluated by the judge sitting on the bench?
By one of these professional.
And I guess that's where my concern is when we have I think you said a licensed psychiatrist.
Right.
The training that a licensed psychiatrist has when it comes to evaluating some of these responses, I think, would be greatly different from some of these other individuals who are trained in an entirely different discipline. And that's a little bit of my concern. If we're looking at two individuals with the same issues that someone is attempting to get guardianship of. That's my only concern.
Well, the only problem is just the court can't get anybody to do them. I think it's a $200 fee the psychologist or the doctor makes, and probably a chance of being tied up in court all day in a guardianship proceeding, and so they don't want to do them. They can't get anybody appointed to go out and do these evaluations, and that's the whole gist of the bill.
Judge, I understand that completely. I want to support you on trying to find additional funding to have individuals work on this, but I would hate to think that, and I'd love to say I don't intend to offend anybody, but most people don't believe that. But I don't think we need to lower the standard when we're talking about an individual's freedom when it comes to guardianship. So that's my only concern, and I think there is a way we can work through this that we can both be happy with.
I'm open to working on it for sure.
Thank you.
We have a bunch more questions.
Okay.
But what I'd really like to do is send you back to work on this bill some more.
Okay.
And we still have time to hear it again.
Okay.
But I think it needs some cleanup unless, yeah. So we're going to hold it for now and not vote on it, and then we can work on it. And we do have another meeting next week, so that if we can get it in better shape to make the committee happy, then we can bring it back.
Okay, thank you very much.
Thank you so much. Okay, well, that concludes our business for today, and the meeting is adjourned. Thank you.